So when it comes to the environment and environmental laws, there's a number of statutes where tribes can go after this treatment as states qualification. And these are situations where the Congress has delegated authority, not the full scope of authority, but there's delegated certain authority to tribes. It is not a subjective standard. There's substantial duties and powers that can be open for interpretation that the EPA has to evaluate. But tribes get jurisdiction over all non-Indians if they're able to get this status. It's basically the pre-qualification process that allows tribes to get tribes as state status. There's no real set process, but basically in order for tribes to get tribes as state status, they need to show that they've got a governing body, they have civil regulatory authority to carry out the laws, so they have statutes, they have an ability to adjudicate, so they have adjudicatory jurisdiction over the areas, that the areas are within their tribal trust territories, so usually there's an inclusion of maps, previous experience in regulating, and other items that prove qualification. But the simplification rule was basically we need to have a simple process for tribes to obtain tribes as state status. Some of the qualifications that are always the same, in addition to the materials that we mentioned that tribes have to provide, is the tribe needs to be federally recognized. So it needs to be a federally recognized tribe. They have to possess a governing body that carries out substantial duties and powers. So we mentioned this, show the tribal council has an experience and that it's a governing body, has an authority. They have to have civil regulatory jurisdiction to carry out the functions they seek to exercise. They need to have that substantive laws, and they need to have the regulatory jurisdiction over the areas. They need to show we have tribal trust lands here, we have laws that apply, we have a habit of regulating. Capability of carrying out the functions, the ability to actually enforce jurisdiction and sovereignty, exercise sovereignty. That could be previous experience, previous cases, projects, enforcement actions against folks, or even just maps that show you that's part of your territory. There's part of the application process usually takes about 30 days, and then if you don't get it, you can ask for reasons why, and then to adjust your application as necessary. Once the comment period is over, you have the EPA review, they have proposed findings of facts, and a final decision. And as I mentioned, if a tribe obtains TAS under one statute, they only had to provide additional information for another statute, and it's a lot easier to get through the process for the other statutes once you've done it for once. So the important question is, why would tribes want to do tribes as state status? And the reason, there's various reasons. One everybody points to first is eligibility for grants and program approval. Basically, tribes get the same access to grants and funding and programs that the states do to regulate these and implement these statutes. Also, what's important is it grants jurisdiction to enforce these acts to the tribes. Without this clear definition and delegation of authority, it's a lot harder for tribes to enforce Clean Water Act, Clean Air Act, and other environmental statutes within their tribal boundaries. It gives regulatory program authorization. It authorizes tribal programs to regulate within their boundaries. And the reason is, if tribes don't get that tribes as state status, you can have people dumping into the water, you can have people dumping into the air, and if you don't have that tribes as state status, it makes it a lot harder for tribes to enforce Clean Air Act and Clean Water Act regulations. These federal statutes do not give states, they do not delegate to states sovereignty or jurisdiction over tribal lands. It does not delegate jurisdiction for the states to regulate environmental laws on tribal lands, which means either the feds would have to do it or the tribes would have to do it. And usually the feds are not coming in to regulate and enforce these provisions. They may in some cases in an absence of a tribes as state status, but really it's going to be easier and more effective if the tribes are the ones enforcing it, and this tribes as state status guarantees that they have that regulatory authority. Federal solid waste codes involve the Comprehensive Environmental Response Compensation Liability Act, and this one talks about, this is really about the major hazardous wastes. That's CERCLA. The other one is the Resource Conservation Recovery Act. Now, under CERCLA, as I mentioned, there is a tribes estate authority, and it contains some differences. So, for example, under CERCLA, tribes do not get the automatic one listing on the priority listing for CERCLA. CERCLA is a super fund that cleans up majorly contaminated sites. Not a lot of tribes have actually accessed this. Tribes usually clean up hazardous waste areas through brownfields funding, which is different than CERCLA. It's slightly different than CERCLA. Now, RCRA, the Resource Conservation and Recovery Act, is really what deals with the day-to-day municipal solid waste and hazardous waste that tribes experience on a regular basis. And so we're going to get into more detail on that in the second module of this training.